Hello and good day everyone. Welcome to the 12th edition of Legal Insight. Today is Friday, the 17th day of April 2026. In this edition of the program, we'll continue our discussion on incorporated companies by looking at safeguards put in place by law to protect the interests of minority shareholders in a company. So if you are a shareholder holding minority shareholding in a company, this video is for you. Let me begin the discussion by stating the fact that when it comes to decisions and resolutions of companies, they are being taken in a democratic manner. This means the majority shareholders will always have their way, while the minority shareholders will have their say. In addition, where there is any irregularity in the conduct of the affairs of the company, or where any wrong is done to the company, it is only the company that can sue in order to remedy that wrong, and it is only the company that can rectify any irregularity. Now, the law, however, has provided certain exceptions with a view to protecting the interests of minority shareholders in a company. Now, we are going to consider these exceptions one after the other. The first exception is in relation to major transaction. Now, generally, the board of directors have powers to approve any transaction. However, when it comes to major transaction, such transaction must be approved by the shareholders at the annual general meeting of the company, and at least 75% of the shareholders must approve such transaction. Now, what is a major transaction? Major transaction include any purchase or acquisition outside the normal course of business of the company. For instance, a company that is into poultry production decide to be purchasing properties can be considered to be purchase or acquisition outside the normal course of business of the company. In addition, any sale or transfer of company's property or other rights that is valued at 50% or more of the company's asset can also be considered to be a major transaction and must be presented before shareholders at the annual meeting of the company for approval. The second exception is the right given to a member to institute an action for declaration or injunction in any of the following instances: where the company is doing an illegal act, where the company passes ordinary resolution in a circumstance that requires special resolution, or any act or omission affecting the person going to court his individual right, or where any fraud is being committed on the company or on a minority shareholders, and the directors of the company fail to take necessary action to remedy the wrongdoing, or where the directors, drive benefit or profit from their negligence or breach of duty, or where interests of justice demand. So in any of these instances, a member can institute an action for injunction or declaration by the court. The third exception is known as derivative action. This is a situation whereby a minority shareholder seeks or applies to a court for permission to institute an action or to intervene in an existing case for or on behalf of the company for the purpose of either prosecuting such case, defending, or even discontinuing the case. One thing that is very important to highlight here is that what differentiates between the second exception and this particular exception is that in this third exception, the applicant or the minority shareholder needs the permission of the court before instituting the action. Whereas in the second exception that we highlighted earlier, the minority shareholder requires no permission of the court. He can simply directly institute the action for the purpose of obtaining the injunction or declaration. Whereas in derivative action, the leave of the court or permission of the court must be obtained. The fourth exception is that a member of a company has right to file petition by application to the court on the grounds that the affairs of the company are being conducted in an illegal or oppressive manner. So if you are a member of the company and you have the opinion that the way and manner the affairs of the company are being conducted is illegal or is in an oppressive manner, you can file petition to the court requesting the court to grant you relief. Due to time constraint, we'll be stopping here. Hope you enjoyed this edition of the program. If you find it interesting, stay tuned for more interesting edition, and thank you for watching.